Good morning, ladies and gentlemen, and welcome to the second day of our colloquium on climate change and the law of international trade. Those who attended the previous session of the Commission, when the possibility and the desirability of future work by UNCITRAL on the area of international trade law and climate change were discussed, will remember the studies that the Secretariat had commissioned from an outside expert who actually spoke at the last panel yesterday. And they covered at the one hand, the topics that is mainly discussed yesterday related to carbon credits and their legal nature, and the other hand, topics more related to liability for climate damage or climate change-related liability. The first reaction of the Commission was at that time, we don't want to consider new causes of action for holding corporations liable. You see that today's program deals with the other aspects of climate change. We talked yesterday about emissions reduction and under Paris Agreement, carbon credits. Today we're talking about other preventive measures of a different nature. And they're not aimed at creating liability as such. We're not talking about climate litigation, at least not in the first part of the session. We're talking about preventive measures in terms of disclosure obligation and due diligence for corporations to prevent possible litigation or to prevent inaccurate claims of climate neutrality. That's the one aspect. The second aspect that will be discussed in the second panel is how corporations in their supply chains can ensure the adherence of all supply chain participants towards climate objectives. What are the contractual mechanisms available? Do they work? Do they not work? Is there in this area any further guidance that might be desirable? Also as regards the application of existing instruments such as the UN Convention on Contracts for the International Sale of Goods. This first panel today focuses, as I said, on preventive measures in terms of disclosure and due diligence obligations for corporations. All this comes also against the broader background of corporate social responsibility. This is a topic that had been the subject of attention by the business sector, but also by intergovernmental organizations. I would name only, obviously from the UN perspective, the UN Global Compact, but the OECD, the Organization for Economic Cooperation Development, had been active also in that area for quite some time and has set various important standards on that. And this is where we will begin this morning's panel, and that will be first hear a presentation by Tiana Boule, who is head of Governance and Multilateral Relations at the OECD Center for Responsible Business Conduct and the Directorate of Financial Enterprise Affairs. She works closely with government and private sector, and she also supports the functioning of the Working Party on Responsible Business Conduct, which oversees the implementation of OECD guidelines for multinational enterprises on responsible business. Tiana Boule holds an MA in Law and Diplomacy from Fletcher School at Tufts University and a BA in Mathematics from Smith College. She's joining us online, and it's my pleasure to give her the floor. Tiana, please.
Thank you so much, Angela, also for that introduction, and good morning, everyone. Thank you for inviting the OECD to contribute to this event. I really regret not being able to be there with you in person. So sorry about that, but I hope that this contribution and the presentation that I will do today will inspire your reflections around whether any updates to any instruments are necessary, and just in general around your work. So today I will brief you on the latest update to the OECD guidelines for multinational enterprises on responsible business conduct that Angelo just mentioned, which are one of the main international instruments that set out what constitutes responsible business conduct in practice. You will actually be among the first groups to hear about these updates. We just launched them, so I'm excited to have the opportunity. What I thought I would do is just give you a short overview of the guidelines, then do a bit of a deep dive on the recent updates that are related to due diligence, climate, and disclosure, and then close with a few reflections around implementation. Just to already plug in that, of course, because these are also new updates, don't hesitate to reach out after the colloquium. I'd be happy to discuss any further detail with you afterward. Next slide, please. So some of you may actually already be familiar with the OECD guidelines since they're integrated in many government policies and industry practice. Really simply speaking, the guidelines are recommendations from governments to businesses that really get at aiming to encourage positive contributions that businesses can make to all areas of economic, environmental, and social progress. But importantly, also to minimize negative impacts that may be associated with operations, products, and services. On the right side of the screen, you see the topics that the guidelines cover. These are basically all key areas of business responsibility, and that really includes also human rights, labor rights, environment, disclosure, etc. Next slide, please. I want to highlight from the start, and this is to what Angelo was saying just earlier, the importance around what already exists in the market, and here the fact that the guidelines align with and complement the UN and ILO instruments in this area. So in particular, the UN Guiding Principles on Business and Human Rights and the ILO M&E Declaration. So these three instruments together have become key reference points globally for responsible business conduct. And this area is this alignment is really critical because it introduces clarity for businesses that are operating across borders. It provides a reference point for governments that are thinking about the smart mix of policies on how to really connect private sector action with broader societal goals. And my favorite, which is that it also gives a practical and realistic framework for how businesses can contribute to broader societal goals. Next slide, please. This alignment and complementarity is particularly important because one of the key concepts integrated in all three of these instruments is the expectations that businesses undertake risk-based due diligence. So it's a process which gives a framework through which companies can identify and address their actual and potential environmental and social negative impacts. And allow me to highlight a couple of nuances here because this type of due diligence is different than traditional compliance approaches. So I want to make sure before I go into the deep dive that we are all on the same page on some of the key terms here. So first, the term risk refers not only to the risk to the company, but also risks to the people, planet, and society, and specifically the risks of adverse impacts on society and the environment. RBC risks can often have financial implications for the company concerned, be it negative or positive. Second point is that the expectation of risk-based due diligence covers the entire supply chain, but it still remains risk-based. And this is important for several reasons. So basically, the idea is that companies should tailor their risk management to the degree of risk that they actually see and face in practice, and to focus their attention on those areas where there are most severe and urgent potential or actual harms. So it emphasizes that and recognizes also the reality of global markets, right? That what companies can feasibly do will differ and be tailored to the size and circumstances of the company or even the sector and the context that a company is operating in. So it does not ask businesses to guarantee perfect results or 100% risk-free supply chains. So really what is emphasized is engagement and progress over blanket de-risking or divestment, for example. Next slide, please. I'm sure this is raising many questions in your mind, and you wouldn't be the only ones. That's actually precisely what we've been focusing on at the OECD. So in order to shed a bit of light on what this risk-based due diligence across the supply chain looks like in practice, and in order to help businesses make the mind shift and implement the provisions of the OECD guidelines, we have been working and setting out practical guidances that really explain in plain language on how to undertake the due diligence. The latest guidance was adopted in 2018 and applies to all business sectors, and it was inspired and it complements existing guidance that we have already had in the minerals, extractive, garment and footwear, financial and agriculture sectors. These instruments have been widely incorporated into market standards and practices. I can give you many examples, but one of my favorite ones is that in the minerals sector, there's now 85 to 90% of global refined gold production audited against the OECD minerals guidance annually by the London Bullion Market Association. So you can really see that industry is also searching for solutions and is embracing the way that a practical approach and a risk-based approach, which makes sense, of course, because of the traditional way that enterprises internally have thought about risk. So what is then new in the updated guidelines? Next slide, please. Or actually, maybe the next one even. What I will do is give you an example of the environment and disclosure chapters, but of course, I also encourage you to have a look at the full instrument because there is a lot of interconnections between topics, and the probably the one that comes to mind is environment and human rights, or climate change and human rights, which are of course quite interesting. So, okay, let's dig into the environment chapter. So when it comes to this chapter, it basically sets out the expectations that enterprises are expected and should conduct due diligence to assess and address their negative environmental impacts, including in relations to climate change and biodiversity. So the updated guidelines are the first international agreement providing government-backed recommendations for enterprises to align with global temperature goals. So our hope was that it would be a compass for private sector that's wishing to align their and those in their supply chain activities with internationally agreed temperature goals. And again, I want to emphasize that the supply chain angle is important because we know from data that climate impacts associated with supply chains, so the scope 3 impacts or with portfolios for investors represent the leading source of greenhouse gas emissions for many businesses and for most investors. I love the data point from the Carbon Disclosure Project, or maybe love is not the right word, but it's an interesting point that a company's supply chain emissions, so scope 3 emissions, are on average 5.5 times larger than scope 1 and scope 2 emissions. And for sectors that are associated with end products, scope 3 emissions will often account for 80 to 90% of total emissions. So, that gives you kind of the extent of the issue. So the main updates to the chapter, you see them on the screen, and they basically include more clarity around what is environmental impact and how companies can think about it, on climate change mitigation and adaptation, around biodiversity, sustainable consumption, production, and animal welfare. I won't be comprehensive. I'll just give you a few highlights on each of these areas, but I do encourage you to have a deeper look. So on environmental impacts and due diligence, as I mentioned, the guidelines now very explicitly set out the expectations that risk-based due diligence is expected on environment and climate change. And then additionally, the guidelines now set out a non-exhaustive list to give direction on how impact should be understood and considered. So it specifically mentions climate change, biodiversity loss, degradation of land, marine and freshwater ecosystems, deforestation, mismanagement of waste, pollution, etc. It also clarifies that environmental impact is to be understood as significant changes in the environment or biota, which have harmful effects. So the idea is not, this carries through this idea of having to prioritize your most severe and urgent impacts. Additionally, we also clarified what causation, contribution, and linkage to an environmental impact from a business point of view looks like, which is a complicated topic because of also availability of data and current science. So what we did is included more guidance and detail on that. So for example, it is explicitly recognized that there may be limitations to carrying out due diligence due to lack of availability of environmental data or technologies, and that prioritization will often not be an exact science. So it provides some flexibility and ability for enterprises to make judgment calls when making prioritization decisions. However, at the same time, it also points to the internationally best available science as a guiding point for those decisions. Now, moving on to climate change mitigation and adaptation, I already mentioned, of course, the scope 3. And there's also an emphasis around generally greenhouse gas emissions, carbon sinks, and guidance around what science-based policies, strategies, and transition plans should take into account. And again, scope 3 emissions here are, in my view, really interesting because we know that in the market there is a lack of coordinated and commonly agreed approach to scope 3 emissions reporting, which may also lead to risk of double counting emissions or misattributions on who is causing these emissions, which is an issue which has not yet been addressed in regulation and guidance, right? So there's also, and on top of that, there's data gaps that represent an ongoing challenge for practitioners. So this risk-based approach is quite practical because it gives enterprises a framework to work with on how to think about these scope 3 risks and also the type of actions that they can take to influence their business relationships to improve climate performance and resilience. So it can really be relevant for addressing some of the current challenges that are associated with measuring and addressing scope 3 emissions. Around biodiversity, sustainable consumption and production, as well as animal welfare, there is now a clear emphasis on practical actions again, as well as additional guidance provided. So, for example, around biodiversity, we've included a specific recognition around biodiversity mitigation hierarchies, as well as further guidance on topics that are relevant, such as land, marine, freshwater degradation, including deforestation, as I had mentioned earlier. Next slide, please. Around disclosure, the chapter updates outline recommendations that are both related to disclosure of material information, but also RBC information, even where RBC information is not considered material. So the main updates include alignment between G20 OECD principles of corporate governance, which you also may be familiar with, including in relation to beneficial ownership, both composition, as well as the concepts around material, what is material information. It also sets out and recognizes the link between how due diligence can support enterprises in identifying what risks and impacts are material. That's an important area because that is still an area of discussion in many parts of the world and in many national contexts. So I will not go into the other kind of set of details, but please let me know in case you want me to dig into that when we go into the discussion part of this panel. Next, and this is what I'm going to end with my presentation. Next slide, please. Next one. I shouldn't have put these section slides. Basically, what we're seeing happening in practice is that despite significant progress over the last decade, we do know and see, it's obvious that there are gaps in approaches and coverage across countries that is really resulting in continued adverse social and environmental impacts. And I wanted to highlight these 3 points to you, which is where So promoting global alignment and avoiding fragmentation, looking at the role of the government in promoting responsible business conduct, and then addressing implementation challenges. These three areas I wanted to highlight because from the OECD point of view and from the Center for Responsible Business Conduct, we really see quite a lot of opportunity to make and to help the market with dealing with practical challenges with the focus on these three things. On the greater alignment and avoiding fragmentation, because we're talking here about the nature of international business, there is really, and it is a very fair question for businesses to not want to deal with different expectations in the market. So there's many benefits to having more alignment and avoiding fragmentation. Then around creating an enabling environment in the role of government, because of the interconnectedness of all of the issues, we're making an emphasis around policy coherence and also thinking about the different smart mixes, what is called in the UN Guiding Principles on Business and Human Rights. But really, it's a reflection within governments around what are the connections between the different policy areas and how they either reinforce or not each other. So I will tell you in a second about the practical tool that we have to help with this. And finally, this idea of addressing implementation challenges, I really want to reemphasize here again that we need to be very careful that with these risk-based approaches in general and the initiatives that we have, that we are actively and proactively working against blanket disengagement side effects and disincentivizing businesses to continue investing in the areas of the world that really need investment the most. So that is really the spirit of this progress and risk-based approach that we've set out in the OECD instruments. Next slide, please. I will end with this. This is the OECD contributions that I wanted to highlight on how these challenges are, how we are contributing to addressing these challenges, in addition, of course, to the instruments that I spoke about earlier. The adherent governments to the guidelines have not just left this common challenge to business. They've also set up national contact points for responsible business conduct, which are agencies established by governments to promote responsible business conduct and help resolve issues. We have also introduced new instruments to assist policymakers. And the one I particularly want to highlight that may be of interest to you is our new recommendation on the role of government in promoting and enabling responsible business conduct, which I'm happy to share with you after the call. And there are many practical toolkits and thematic materials that we work with both with business and with governments. And here I want to highlight in particular our work around investment and specifically the FDI Qualities Project, which recognizes that positive impacts of FDI don't always materialize, and to really try to help government and stakeholders address that when that happens. And the pictures that you see on the screen, and this is my last point, is that we just in February hosted a first ever ministerial meeting on responsible business conduct. So I would really encourage you to have a look at the ministerial declaration that was signed by 50 governments around the strategic direction and the areas that they see are priority areas for addressing these common challenges such as climate change that we have. So I will end with that. You will see on the last slide my contact information. I thank you for your attention and the opportunity to feed into your thinking. Please count on the OECD as you move along in the process. Don't hesitate to contact me. We would be more than happy to support your thinking and share further information on all of these instruments. So thank you again very much.
Thank you very much, Tiana, for this very comprehensive presentation, and it really sets very nicely the stage for the discussions that we'll be having in this panel. And thank you for making time for being with us update remotely. I'm sure there will be many questions that will be directed to you during the Q&A session at the end of this panel. Our next speaker is Ms. Meng Su. She goes by Molly in the West. She's a partner KWM's Finance and Securities. Her practice focus on project finance, syndicated loans, outbound finance, acquisition finance, investment and incorporation financial institutions, derivatives trading platforms, and general banking. She graduated from the University of International Business and Economics. She has an LLM from Sheffield University and CPE from Sussex University. She joined King and Moot Mallesons in 2006 and was admitted as a Chinese lawyer in 2008. She's proficient in Mandarin and English, and we're welcome that she made it all the way from China to here and joined us yesterday. And the floor is yours. Thank you.
Thank you. Good morning, dear guests, colleagues, and the moderator and the fellow panelists. My name is Su Meng, and I'm a Chinese lawyer specializing in cross-border financing. Over the past few years, my team has been dedicated to exploring China's rapidly expanding carbon market and cross-border carbon financing. It's a great honor to be here to share with you China's efforts in increasing voluntary emission reduction and to improve carbon data transparency in recent years. Firstly, I would like to provide a brief overview of China's carbon market. China's carbon market is comprised of two main segments, the compliance carbon market and the voluntary carbon market. The compliance carbon market is the China emission allowance trading system, and the voluntary carbon market that is focusing on the China certified emission reduction. Currently, both the compliance market and the voluntary market in China are experiencing rapid growth and development. Firstly, let's look at the compliance market. The national ETS was launched in 2021, which trades CEAs, and the national ETS is targeting the power generation sector and is covering 45% of the national carbon emissions. By the end of 2022, the cumulative trading volume in the national ETS has reached over 200 million tons, while the cumulative turnover reached over 10 billion RMB. So if we look at the amount of greenhouse gas emission covered, China is already the world's largest carbon allowance trading market, and the volume of the transaction in China's carbon market is also steadily increasing. Before the establishment of the national ETS, China had been conducting pilot program for local ETS since 2011. These local ETS are implemented in cities such as Beijing, Tianjin, Shanghai, Hubei, and they have witnessed remarkable progress. By the end of 2022, the cumulative turnover of these local ETS exceeded 10 billion RMB. So each ETS has tailored its own policies to suit their own requirements and even trading varieties, methods, participants, and other relevant aspects. So allow me to elaborate further with some examples. Firstly, in terms of the trading methods, several pilot regions such as Beijing, Hubei, Shenzhen, and Guangzhou, they have not only developed spot trading, but also ventured into financial derivatives services for carbon emission trading. Secondly, when it comes to participating entities, in Shanghai has expanded the scope of industry into beyond energy-intensive sector. For example, they have covered sectors like food manufacturing. Similarly, in Guangdong, has extended the coverage of Guangdong carbon market to include sectors such as ceramic, textile, data center, public building, and transportation. These proactive measures have positioned these regions as pioneers, setting an example to the rest of the nation. China's carbon market is poised for expansion and the development of a unified national carbon trading platform. The various local carbon ETS will be integrated into the national market. Additionally, sectors beyond power generation, such as petrochemicals, chemical engineering, and steel, are expected to be included in the national ETS very soon. This demonstrates China's commitment to addressing emissions in various industries and promoting sustainable development. Financial institutions are also increasingly engaging in carbon market. Like recently, we have six security companies have received a permit from the security regulator to participate in carbon trading, and they even can do proprietary trading in the market. And the development of financial derivatives product is also attracting the attention from the whole market. So Guangdong province, for instance, has a plan to introduce carbon future tradings products on the Guangzhou Futures Exchange. In terms of the carbon trading infrastructure, Shanghai Clearing House treats carbon as commodities, and it provides central counterparty clearing services for CNY emission allowance forward trading. Additionally, Hubei has proposed the creation of a clearing infrastructure for spot and derivatives carbon trading. And let's look at the voluntary market. CCER was originally launched in 2012, but the market development after 2017 has been relatively slow. The Ministry of Ecology and Environment is promoting a construction of a centralized voluntary emission reduction trading market, and they plan to reopen the trading for CCER this year. In July 2022, Hainan Province, Hainan International Carbon Emission Trading Center was launched, and for the purpose of promoting cross-border carbon trading transactions. In January this year, the first cross-border carbon trade was executed, involving the trading of VCU under the globally recognized platform VCS. This trade was originated from India, and the total volume of the trade is over 10,000 tons. In October 2022, Hong Kong Exchange also introduced a new international carbon market called Colloquium. The participants on the platform can engage in voluntary carbon credit trading. So China is making progress in opening up its carbon market to foreign investors through a pilot program. Since 2014, the qualified overseas investors have been allowed by the State Administration of Foreign Exchange to participate in certain carbon local markets. Additionally, companies like the Chinese SOE CICC are globally allocating their carbon assets, and they can even do carbon spot trading in Singapore's international carbon market. After briefly introducing the carbon market in China, I would also like to share with you some information about China's efforts in improving carbon data transparency. Since 2020, China has implemented policies promoting private sector's environmental information disclosure through a combination of voluntary and mandatory measures to enhance transparency, responsibility, and incentivize emission reduction for sustainable development. So first, listed companies are encouraged to disclose environmental information. For instance, the China Security Regulator, CSRC, will encourage listed companies to disclose information regarding the verification, appraisal, and evaluation of their environmental information. And also Shenzhen Stock Exchange and Shanghai Stock Exchange also promote the disclosure of pollutant data of listed companies in their social responsibility reports. Moreover, the regulator of state-owned enterprise also encourages listed companies controlled by the SOEs to disclose ESG reports. This emphasizes SOE's role in leading sustainable development practice through comprehensive environmental information disclosure, also reflecting the government's commitment to data transparency and responsible corporate behavior. So voluntary environmental disclosure not only helps companies to establish a positive social reputation, but also help them to get financing. The Chinese banking regulator requires banks to consider environmental reports during corporate financing reviews. So in China, we have green loans and also the sustainability-linked loans, under which the sustainability-related activities are linked to the commercial terms of the loans. For example, if the borrower reached a target carbon footprint ratios, the financing cost will be decreased accordingly. China has also established a mandatory mechanism in the field of environmental information disclosure. According to the relevant laws, companies are obligated to disclose their environmental information in a timely, truthful, accurate, and complete manner. And currently, the enforcement of environmental information disclosure in our country primarily rely on the administrative penalties and civil liabilities. If any private enterprise fails to disclose environmental information truthfully, accurately, in the manner prescribed by law, it will face orders of corrections from the government authority, also public notices of criticism and penalties. The penalties can be up to 10,000 RMB. And for the civil liability, the listed company and debt-issuing enterprises must disclose investment details, including climate change and environmental issues of their financed projects. Key pollutant discharging companies and their subsidiary, and also the listed company in specific industry, such as thermal power generation, are also required to disclose environmental information under the securities law. So failure to comply may result in joint liability for compensation. In addition to encouraging enterprise to disclose true, accurate, comprehensive environmental information through this combination of voluntary and mandatory policies, China is also making attempts to guide these enterprises on how to standardize the disclosure of environmental information. For example, we have a guideline called Corporate ESG Disclosure Guideline, which provide Chinese companies with a domestically adaptable framework for disclosing environmental information. Similarly, China's central bank also issues a guideline called Guidelines on Environmental Information Disclosure for Financial Institutions, which specifies the qualitative and quantitative information that should be disclosed by the banks. After introducing what the government has been doing, we could also take a look at what has already been done by the private company. So Chinese companies disclose carbon emissions data in two categories. One is corporate emission report, and the other one is product carbon footprint report. Many Chinese enterprises has disclosed carbon emission data in their carbon neutral reports, such as Alibaba Group and Tencent Group. Some company even publish carbon neutral verification reports for their specific products. For example, Yili Group's yogurt and Envision Group's wind turbine industry report. So most reports are verified by third-party certificate bodies following international accounting standards, ensuring a certain level of international recognition. I would also like to introduce an interesting topic, how individuals in China participate in the carbon emission reductions. We have some platforms such as Ant Groups, it's called Ant Forest. And also we have NEO's Blue Point program and also Dida Chuxing's project Blue Points. And on these platforms, users could reduce their personal carbon emissions through low carbon behavior. For example, in the Ant Forest, an individual user could earn rewards by, for example, driving bicycle instead of driving cars to work. Then they could receive a little ball of green energy, and they could use this green energy for planting real trees or claiming protected land by Alibaba Group. These personal carbon account systems facilitate individual engagement in carbon emission reduction and environmental protection, and lowering the participation barrier and costs. So I personally believe that encouraging all the individuals to reduce carbon emission is even as important as to encourage the companies. So now we can ask ourselves what more we can do. So firstly, we can further opening up the carbon market to investors. And also the second, like we can promote carbon finance and derivatives products, which will enhance the effectiveness of the carbon pricing mechanism through carbon trading and encourage greater participants from the emission-reducing enterprises. And thirdly, we could also keep promoting the international recognition of China's carbon data and assets to enhance the standard system and the certification accreditation system. And this is to encourage domestic certification bodies to participate in international carbon emission certification programs and international carbon emission certification system with mutual recognition. So finally, I would like to thank to UNCITRAL again for giving me this chance to introduce China's efforts in addressing climate change. Apparently, there were still a lot more we could do, but we should continue to collaborate and share the best practice to create sustainable and prosperous futures for us all. Thanks.
Thank you very much, Molly, for this very clear and very informative presentation, both because it also complements information already had yesterday of the Chinese carbon market, but also with the focus on you have added on due diligence and disclosure, which is the specific topic of our panel. Thank you. So again, thank you very much for that. Our next speaker is Veselina Haralampieva. Veselina is a senior counsel at the European Bank for Reconstruction and Development, EBRD, in London, where she leads the climate change and sustainability policy and law reform work of the EBRD's legal department. She's one of the originators of the EBRD's corporate climate governance facility, which supports private and public sector companies in strengthening their governance and management of climate-related risks and opportunities, and it centers the EBRD's Paris Agreement alignment approach. Veselina is admitted to practice as solicitor in England and Wales, and she is a lawyer graduated in her native Bulgaria. And she has also a law degree from Harvard Law School and Sofia University. Veselina, please.
Thank you very much, Angela. And let me thank you to the Secretariat for your invitation. It's a real honor to be here and to address this esteemed audience. My contribution today would be to talk to you about the work that we have done at the European Bank for Reconstruction and Development in promoting corporate climate governance. This is work we have done with private sector clients, meaning we work very closely with financial institutions and with corporates, as well as state-owned enterprises. So drawing on the voluntary frameworks on climate and sustainability-related disclosures over the last few years, we have developed policy and investment products and requirements for our clients that we integrate in our investment offerings that are aimed at increasing awareness and catalyzing businesses' climate ambition, guiding their climate action, and ensuring sustainability, accountability of their decisions. I will briefly mention a case study that we have done, and building on the lessons learned, I'll also highlight areas that we have identified that would benefit from some more clarity and harmonization on a global scale. So climate change, the topic for today and yesterday's colloquium, is the defining issue of our times, with far-reaching effects, as we've seen, on national economies, but also in particular on businesses. These linkages between climate change and individual businesses are becoming more and more apparent. Climate change is now widely recognized as a systemic risk to corporations, financial institutions, and broader economies. On a national level, we have seen the impact of climate change that is measured in lost homes, lost livelihoods, lost businesses, and lost lives. Research has concluded that climate-related risks could have severe impacts on the businesses we work with in emerging markets, frontier economies in particular, including on their portfolios, their assets, as well as in their supply chains. So if left unaddressed, climate change will bring about profound negative economic consequences, not only on the broader financial stability, but also on the individual firm's value. And so what recent research also has pointed out to a drop of stock prices of businesses in result to direct impacts of climate change as well as indirect through climate litigation, about which we will hear a bit later today. And so this is what the EBRD is looking at, as well as many of our partners, including the Network for Greening the Financial System. So this is a group of more than 40 national financial regulators and supervisors. We are an observer and we contribute to various working groups. So the product of this work is to help businesses develop, to help central banks identify clear climate-related disclosure guidances and mechanisms in order to be able to kind of push the markets where they operate, the markets they oversee, in order to start collecting this data. As we heard, data and disclosures are key. So we need to transform the way we do business. And the shared goal at EBRD, the shared goals of our economies and our shareholders, is to reorient our economies towards economy that is low carbon, resilient, and environmentally sustainable, and to align financial flows, our financial flows, and those of our partners with those ambitions. As a first step towards Paris Agreement alignment, which is an objective for EBRD as well as other sister multilateral development banks, is to help the private and public sector entities identify climate and sustainability related risks and opportunities to their assets, portfolios, and supply chains. Of course, just as an aside, in addition to our focus, main focus on the private sector, we also work with national authorities and regulators in developing policies and national legislation to help countries deliver on their nationally determined contributions. So effectively, in order to help businesses identify such risks, we believe that embedding climate change into corporate governance is essential. This is key to provide organizations and business leaders with the information that is needed in order to address climate-related risks and to build on the opportunities as they emerge. So there is a growing consensus that climate and sustainability-related data is essential to monitor the progress towards achieving the Paris Agreement goals. The problem for many of our countries' operations is that there is lack of such data. There has been traditionally the corporate governance frameworks have not been exemplary, to say the least. And climate-related data, disclosure data, relying on this corporate reporting is simply not available. So the voluntary market-driven standards on a global scale have emerged, and they set these disclosure requirements for entities, guiding them how to identify, how to assess, manage, and disclose sustainability and climate-related matters. The recommendations of the Task Force on Climate-Related Financial Disclosures of 2017 is the first voluntary framework that enabled companies to incorporate and disclose climate-related financial risks and opportunities. EBRD is the first multilateral development bank that subscribed to TCFD and the first one that issued our own TCFD report. The TCFD recommendations have become the springboard for the rise in initiatives that integrate climate and sustainability considerations into corporate governance and decision-making, and the most recent one is the sustainability standards published by the International Sustainability Standards Board under the umbrella of IFRS. So what we have seen is over the last 4 years since TCFD recommendations became become a good market practice. A number of developed economies have introduced legal requirements that introduce such disclosures into their legal regimes. This hasn't happened in emerging markets. And there are hopes that now with the new ISSB, with the new IFRS-supported Sustainability Disclosures Board, there will be a greater consensus and a greater coherence of implementing and addressing sustainability disclosures at corporate level. But the key here is that financial markets need data and need corporate disclosures. To support these needs in emerging markets, we have developed a corporate climate governance facility. This is really at the heart of our engagement now with financial institutions and corporates. And in fact, as part of our Paris alignment approach, we have committed to look beyond the use of proceeds, the project's use of proceeds, but really to look at how we can support our clients on an institutional level. We call it a counterparty assessment, which really looks at our client as an institution and their governance, their strategic documents, their governance processes, policies, the way they manage risks, and all the support mechanisms and capacity that exist in an institution to be able to credibly disclose how they manage climate and sustainability risks. So we were the first financial institutions that developed such a facility. We're relying on our donors with the initial budget of more than 30 million euros. We launched it at the last COP. And this facility really supported internally at the bank by lawyers, technical experts, also by bankers, and it really focuses on engaging with our clients, being their partners, not judging, but providing all the support that they need. So this is really very much guided by the objectives of the facility, and this is when we work on with the financial institutions or a company or a corporate, we focus on establishing the appropriate internal and governance and operational arrangements, developing internal capacity, and establishing these management practice guides and policies and practices. What I would like to highlight is that through our work, the reason we developed it and the way we are mainstreaming, and we are very much also in dialogue with other international financial institutions to help them see the value and develop the internal support mechanisms to offer such support, to offer such technical assistance to their clients. The level of awareness and readiness for climate-related financial disclosures vary widely across regions, across sectors and businesses. In our EBRD regions, we have observed that the majority of companies lack such capacity. It's even difficult, the very first engagements, because there is not sufficient knowledge, there are no processes, no even expectations at their national states, at their national level, to start collecting such climate data and to really use it first to inform the way they take decisions and the way they develop the company prospects and identify new business opportunities. We also see the benefit of these climate-related disclosures for clients in the mid to long term, because this would, of course, open more opportunities for them to access finance on the international markets by EBRD, of course, but also by other partner financial institutions. So, as I mentioned, so we work on providing the tools and technical assistance. Quite often we work on developing, providing the support and sometimes the methodology. So we develop the methodologies for clients in line with SBTI and other international standards. to develop their decarbonization plans, their transition plans. So even in the lack of national regulatory regime that is asking them to do so, we work with them to internally to change the mindset, to change the culture, to help them identify opportunities beyond the business as usual. And critical for that is to develop such transition plans and governance mechanisms that will really help them identify what are the climate-related risks for them and their supply chains, how they can identify the green opportunities, and how they can undertake investment decisions and actions that are consistent with the global and specific industry net zero trajectory. So this is very much also, we look at the national level, of course at the global level, but also some of the key industries are very much now in the process of developing guidance and trajectory how to align with net zero. So one example I want to quickly give you, a case study that we did in Tunisia. We started in 2020, very early engagement, so it was like 6 months really of explaining what really the value added will be of this project with the state-owned energy utility. This is Société Tunisienne d'Électricité et du Gaz, or STEC. STEC is the central player in the domestic energy sector, as it's solely responsible for distribution and transmission of electricity and gas. It acts as the single buyer for all generation output and controls electricity generation. So we have worked closely with the Ministry of Energy on the one hand as the main shareholder in the state-owned entity, and with the company itself. We developed a roadmap, as we call it, Corporate Climate Governance Action Plan, looking at the 4 key pillars following the TCFD areas of excellence, but also really looking at, while TCFD the way, and now ISSB the way we have seen is that they're very, very helpful as global baseline, but also they are very much advanced in expectations. And sometimes not quite consistent with where the corporate governance is in emerging markets. So this action plan actually develops a roadmap with clear timelines and milestones of how companies should develop their climate governance, their risk management strategy, processes, and prepare for disclosure. So as an outcome of this project, it was quite beneficial for STEC, but also for the contribution to the national determined contributions, the plan. So now, after our work of almost 3 years, after we have gone through many board meetings and discussions, the STEC for the first time prepared their corporate governance strategy, which incorporates a very significant climate governance and decarbonization plan. STEC is now expected to contribute to more than 40% of the mitigation objectives of the Tunisia's NDC by substituting gas with renewable energy. So this was the main objective. It's really to have also demonstration effect in the region of how businesses could embrace the climate agenda by identifying opportunities and not necessarily looking only at the burdens and the costs that are involved. So what are 3 areas that we have identified that we feel will benefit from some more harmonization? One is more on the governance, so governance level, internal policies, really directors' duties. It is now evident that effective climate governance is very much crucial to good corporate governance. So there is a discussion of duties of directors and climate change in the past, and whether such duties incorporate climate-related risks. Really, now I think this discussion has moved is how this duty should be fulfilled, how directors should be also supported in order to identify what their role is in the board to steer their companies towards a net zero trajectory, towards more sustainable business models. We as a bank work, as I mentioned, on a company level, but also we have very much developed closer partnerships with the WEF, so the WEF's endorsed Climate Governance Initiative. They're based in Cambridge. And it's a voluntary organization aimed at supporting setting up national chapters for senior executives at companies also in emerging markets. So just a couple of days ago, we launched such a chapter 0 in Egypt. We have recently launched in Uzbekistan, and we will launch next week in Turkey. What is the value? It's a voluntary initiative, but really we see the transformation effect when we connect the decision makers in this kind of community of future leaders, of sustainable leaders, to discuss amongst themselves what really their duties are at the company in line with the sustainability development goals and with the Paris alignment. So we have also found that at the national level such guidance will be very helpful in order to help boards and directors identify what are their fiduciary duties effectively in the change in the face of these changing realities. The other point was on greenwashing. I think this is very, very important point. I'll very quickly just mention that what we have seen, of course, over the last couple of years in developed, but also in developing countries, is how private sector private sector companies, financial institutions, and corporates really label themselves as green, environmentally friendly, net zero, sustainable. And there is no guidance internationally on what this would entail. And this is quite important because there are risks, litigation risks, of course, for directors and the board, directors at an individual level, but also in the board as an institution. There is also the kind of this chilling effect. If there are no guidance, then directors would really not approve any climate-related disclosures or any statements about sustainability. So a number of countries have taken some steps, including the European Commission. So that will be quite critical. And finally, the supply chains. That's the introduction of corporate sustainability due diligence laws. Is quite important for giving also some transparencies on a national level of what would large corporates expect to report on in line to report on not only for their risks and impacts on climate and sustainability, but also to work with their supply chains to minimize such risks and impacts, and of course nature-based dependencies. So I will wrap up with that. I just wanted to conclude and say that without this fundamental, in order to deliver on the net zero goals, in order to meet the Paris Agreement 1.5 degrees Celsius, we really have to start thinking about changing the way we do business, changing the way we regulate the private sector and public sector as well. So we're calling for a closer collaboration between the private and public sector on accelerating the global transition to a net zero economy, together with boards, financial institutions, and the broader range of stakeholders, with the help of institutions like UNCITRAL. We must really kind of enable a new wave of businesses and business leaders that would champion the net zero agenda and will deliver on the sustainable goals. Thank you very much.
Thank you very much, Veselina. I think there was also a very broad spectrum of issues that you reminded us of, and also drawing connections to the following panel, the supply chain governance, the way this obligations and also trickle down the supply chain is also an important issue to discuss. And also this aspect of fiduciary duties of managers and how that all links in the puzzle. And I think was a very good way of supplementing the two previous presentations. Now, we heard two representatives of the international public sector, one representative of the private sector, and now we go to another representative of the private sector. Our next speaker is Katharina Bryan. Katharina is head of sustainability reporting and environmental, social, and governance public policy at Amazon. She leads engagements in the EU, UK, and also and internationally participate in the work of ISSB. Before joining Amazon, Katharina had worked at the European Court of Auditors, ECA, an EU institution that is based in Luxembourg for 13 years. Katharina holds a doctorate in economic and social science from the Vienna University of Economic and Business, a master's in European law from the University of Liverpool, a master's in international business relations from the University of Applied Science in Burgenland in Austria. And also Katharina is also, she is not speaking on behalf of the ICC, but Katharina is a speaker that was really commended to our heart by the International Chamber of Commerce as to participate in today's colloquium. Thank you very much for joining us, Katharina. The floor is yours.
Thanks very much. Thanks very much for this invitation here. Thank you for UNCITRAL for setting this up. Now, I've been asked now several times, and this morning at breakfast again, what's Amazon doing here when I present myself? Now, Amazon has been integrating sustainability into our decision-making, and we are preparing ourselves for the new disclosure requirements. So over breakfast, I said, that's what I'm here. I'm going to talk about sustainability reporting, trends and challenges from a corporate perspective. And when I say sustainability reporting, it is actually I'm referring to disclosure and integrating sustainability into the business. Now, yesterday, and I've just got one slide here, which was already mentioned, Chris from IOSCO mentioned that the alphabet soup of the different frameworks of sustainability reporting. Now, as an Austrian, I like my alphabet soup, but I will try to bring some clarity into this world of acronyms and reporting. I'll start by two global trends in the reporting space, and will then focus on the EU, on the Corporate Sustainability Reporting Directive, and that's why I wrote it out. It's all one of those acronyms. And then on the International Sustainability Standards Board, 2 new disclosures. They have the aim to increase transparency and accountability for climate change and sustainability. I think you can click away this slide now. Now, the trends, 2 trends. We see a transition from voluntary to mandatory reporting. So for lawyers, from soft law to hard law. Reporting in itself and frameworks are not new. The Global Reporting Initiative, GRI, last year marked 25 years in existence. But what we see is the creation of an acceleration of voluntary frameworks. That, for example, has already been mentioned with the Task Force on Climate-Related Financial Disclosures, the TCFD, which was released in 2017, to drive a company's and investors' understanding of the potential financial implications associated with transitioning to a lower carbon economy and climate-related risks. You'll be aware of the UN Guiding Principles on Business and Human Rights, 2011. We've just heard about the updated recommendations from the OECD Guidelines for Multinational Enterprise and Responsible Business Conduct. And there are also the Sustainability Accounting Standards Board Standards 2011. There are many more, and the number is growing. For example, Wendy mentioned yesterday the Task Force on Nature-Related Financial Disclosures. So companies have used these guidelines and frameworks for reporting. For example, Amazon has been publishing a global sustainability report since 2019. We inform our current reporting by different frameworks: the Sustainability Accounting Standards Board, the Task Force on Climate-Related Financial Disclosures, the TCFD, and the UN Guiding Principles. What we are observing now is a transition from voluntary to mandatory reporting. And these mandatory reporting regimes and initiatives transpose many of the voluntary regimes into hard law, and at the same time develop them further and deepen the standards. So the EU, the European Union, is most advanced in terms of timing and built its standards on many of all these alphabet soup frameworks. The International Sustainability Standards Board, the ISSB, published a couple of weeks ago, builds heavily on the TCFD, and some countries, such as the UK, had already made it mandatory. As you may likely know, in the US, the Security and Exchange Commission, the SEC, is also preparing rules in this area. So there's already a lot in motion on legal frameworks on reporting. And in the EU, we support the EU's intention and aims of having one framework for sustainability reporting because, as has been mentioned in the OECD presentation, it's much simpler to have one framework and it's more coherent. The second trend, what we are observing, is that there's a convergence and at the same time a divergence in reporting frameworks. So let me explain. The new reporting frameworks that are emerging have a variety of scopes and breadth of reporting. Also, on organizational level, we see a convergence. We see that the ISSB has incorporated some voluntary frameworks. They're now, from next year, taking over the TCFD. And content-wise, the ISSB aims to provide what's called a global baseline for reporting. But I just caution that despite these certain consolidations, we see that companies that operate globally will continue to be faced with a variety of frameworks. In order to comply with these transformational reporting requirements, companies need to reevaluate their organizational model and upskill various departments with both ESG, so environment, social governance expertise, and traditional financial reporting expertise. And we are on this journey. So I'm going to speak and zoom in into two areas, two frameworks, which we are currently preparing for. The EU, we are preparing for it, and ISSB, we are following it closely. It has just been issued. Zooming in on the developments in the European Union, we see that the new Corporate Sustainability Reporting Directive extends comprehensive sustainability reporting to around 50,000 companies in the EU. And the EU has developed a set of 12 general standards which apply across all sectors, and they cover a range of sustainability matters from environment, social, and governance. These standards were prepared by an expert body with a wide participation and consultation in a transparent process and several consultation rounds, so which enabled all kinds of stakeholders to comment. And some of you who are deep into this space might know that the consultation on the final drafts just closed last week. So this EU legislation is part of its sustainable finance framework. and the need to channel investments towards sustainable investments. So investors need to know more about sustainability of their investments, simply not to end up with what we call stranded assets. The EU's legislation is also a response to demands for increased transparency on corporate sustainability performance from customers and suppliers. So this means the EU's framework is the more and most comprehensive one we are faced with in comparison with the ISSB. The EU, for experts, calls it includes something which is called double materiality, which basically means that the EU is looking at financial materiality, so how is the business impacted by factors like climate change, and how does the business impact the environment, social factors. For examples, the EU requires detailed rules to disclose the impact a company has on the environment, people and the planet. In the environmental field, it is water consumption, other resource use, waste, biodiversity. It also requires that companies have a transition plan on how the company will work towards the EU's objective of climate neutrality by 2050. So this includes the disclosure of emission reduction targets. And this is one example I just like to mention, that it's not just about disclosing of what your is, but it actually includes target setting. The final point on the EU framework I would like to mention is the use of auditors. Now, as you mentioned, that matter is deep to my heart because I was working for 13 years for the European Court of Auditors, and actually the last time I was at the UN, I talked about the role of public sector auditors in providing assurance and accountability on reports on sustainability. So here this is really key, that the information that a company publishes needs to be audited. And the auditor has to provide limited assurance. So this means information we publish will be independently verified, like financial reporting. So that's a move to bring sustainability reporting closer to financial reporting. So now come to the ISSB, the international developments. We saw the ISSB published its framework on the 26th of June. The first set, 2 standards called S1 and S2, simply, together with a suite of sector-specific guidance, which were previously known as the Sustainability Accounting Standards Board. The ISSB has been set up by the International Financial Reporting Standards, the IFRS Foundation. And these standards are focused on for companies to communicate to investors about sustainability-related risks and opportunities they face over the short, medium, and long term. We have to disclose and will have to disclose the effect of climate-related risks on the company's prospects. So they focus on climate first. The ISSB, I have to say, is also currently consulting on its future agenda and whether it should go into other areas such as human rights, nature, or biodiversity. Now, as lawyers, you'll know that the ISSB does not automatically apply. Countries can decide to adopt the ISSB standards for their own jurisdictions. We already see several countries, such as the UK, Australia, or Singapore, have declared their intention, and actually some of them are already consulting on that. So for a business, the impact of these frameworks will depend on which jurisdictions and when, as well as how jurisdictions will approve and adopt these standards. So we see that already a lot is happening in legal frameworks on reporting. But for us, consistency and coherency is needed. As global business, we need interoperability between the frameworks. Engagement between policymakers and standard setters will be important to support interoperability and coherence in reporting framework as far as possible. Deviations between and from frameworks is about cost for business, and too much reporting risks distracting the actual work on decarbonization. But deviations between framework also concerns comparability for investors and other stakeholders and regulators and you policymakers. Now, I'll conclude by having the end in mind, the finalité of sustainability reporting. In the end, sustainability reporting is not about publishing a report, but it's about business transformation. The standards are intended to drive sustainability into the business, so this is more than a compliance exercise or reporting. The metrics you should measure should aim to better inform corporate planning and reduce our impact in a way that matters for both of our customers and the planet. So we see these regulations are an opportunity to accelerate decarbonization initiatives. Now, throughout this colloquium, it has been pointed out that collaboration is important, and transformation cannot be achieved alone. So this is why, in 2019, Amazon co-founded and was the first signatory of the Climate Pledge, which calls on organizations to commit to reaching net zero carbon emissions by 2040. 2040, that's 10 years ahead of the Paris Agreement. There are now nearly 400 signatories of the Climate Pledge. These Climate Pledge signatories span 55 industries and 35 countries. That matters for action, as the signatories have agreed to implement decarbonization strategies in line with the Paris Accords through real business changes and innovation. This also impacts for climate disclosures because the signatories have agreed to measure and report greenhouse gas emissions on a regular basis. So that's just an example for Amazon and how we've been integrating sustainability into our decisions. And so that's why I'm here today. That's what I told the lady at breakfast. And then she said, well, I'm here for the anti-corruption conference. But she was happy to learn on climate change anyway. So thank you very much.
Thank you very much, Katharina, for this also very comprehensive, informative presentation of perspective of the private sector, stressing also both the commitment on the one hand, but on the other hand, the need for clarity in the rules of the game and consistency and also interoperability. At the end of the day, there's a common interest of avoiding greenwashing and avoiding investment fraud claims and that type of reactions from the market. There are also a need for a level playing field that is predictable and that everybody can rely on. Now, that concludes this part of the panel. Now we have time for questions. And I open the floor for questions. But if you don't have anyone immediately, I will perhaps get the ball rolling. I use my prerogative as moderator to ask a question to all panel members. And that is it's one issue, but that has two dimensions. That is the extent to which some of these reporting duties and due diligence obligations can adequately, or should they serve as safe harbor to protect corporations from climate change litigation on potentially open grounds and potentially unlimited exposure to climate change litigation. The latest report published by the UN Development Programme on climate change litigation is already 3 years old. It's 2020, and already that year was indicating that as of 1st July 2020, there have been at least double the case of climate change litigations by reaching 1,550 claims filed in 38 jurisdictions around the world. What is the role, in our view, the role of standards and due diligence obligations, perhaps in reducing the risk exposure also of corporations on the one hand, and also the impact that attack also has internally within a corporation as regards fiduciary duties of managers, to what extent compliance with a voluntary or mandatory standard can also be as a means of reducing or exposure to liability, and also related to that, the extent to which the current uncertainty and also possible discrepancy and lack of uniformity on standards may not inadvertently discourage corporations from committing to achieving climate goals out of fear of litigation. So I address this question to all members of the panel as the audience are thinking of their own questions to ask to you. So would you like to start, Johanna?
Way to put me on the spot, Angela, with a tough question. I'm not a lawyer, so I will not, I think, get into kind of the details. But what I would say is that it is logical to me that any company that does face litigation would want to showcase that they are doing their best according to the current best practice to address the impacts, whether or not whatever the outcome of the litigation may or may not be. And we've seen that in some courts that a lot of companies are pointing out to all of the risk management frameworks that they do have established, their due diligence practices, as a way to showcase that they're taking the issue seriously. So I'll keep it at that because I'm actually more curious to hear what my co-panelists will say on the topic.
Veselina?
Thank you, Angela. That's a very valid question, and I just would like to add a couple of points. So, litigation, and climate litigation in particular, is a tool, and there is a risk that always will exist. So, what we really also tell our clients is that you are much more likely to face litigation if you do not engage with your broader group of stakeholders, with your supply chains, and if you do not publicly report on how you're managing climate litigation risks and how you are aiming to reduce your climate and sustainability impacts on the environment and society. So that's very much, I think, the understanding that's shared amongst our clients. Now, how to mitigate, and I think this is brings to my some of the points that I made, is in order to mitigate these risks, companies, and that's the value of this corporate climate governance approach or sustainability governance, is that each net zero sustainability or climate claim as such of a business needs to be substantiated. And disclosure is not the aim necessarily. It is really a driver to set your internal processes in place. So what we have seen is this leads to a more joint work between the financial, the risk management functions, and sustainability, and establishing clear processes to the board. So fiduciary duties is really, really important, because then the board will take ownership of those issues. So then once they discuss it at the board, and there is evidence as well that this is part of the agenda, this also is a mitigant to climate litigation. And of course, greenwashing would be mitigated if the claims are substantiated by clear, tools and targets and management techniques. So for me, mitigation of climate litigation can be done only through kind of a holistic transformation of the entity, integration of the functions, working with the stakeholders, and the board taking really ownership of those issues.
Thank you, Molly.
As I actually introduced earlier in my presentation, at the moment, because the regulations regarding the carbon disclosure or the climate change disclosure for the Chinese enterprises actually only at the early age. So the obligations for the private enterprise are mainly voluntary disclosing. Obviously, we don't have too much real cases to be tested in the courts, but according to the practice, actually, the regulation against the company to disclose mandatorily will be stricter and stricter. And also, for example, for the state-owned enterprise is much stricter than before. And the state-owned enterprise need to take a leading role in the market to show a good example for all the other private sectors. And also, the government need to strike a balance between, the economy after the COVID pandemic is getting not very good, and all the governments need to at the same time boost the economy and also keep some extent of the responsibility to the private enterprise. So I think it's important to strike a balance.
Thank you. Katharina?
Well, my reply is not going to be so different. That yes, disclosure and sustainability reporting is about substantiating and changing your business conduct, substantiating the information. It's going to be audited to limited assurance standards. And also, I think in this area we haven't touched upon here. I mean, we've got other proposals as well, which we are monitoring on the EU's Green Claims initiative, where again we welcome the objective because we have a climate pledge friendly program to support the consumer make more sustainable shopping choices, and here we use third-party assessment, so really being transparent again. Now, you mentioned safe harbors, and I think it's also interesting, and that might be something you could also consider, is the nature of the information we have in climate disclosures is sometimes more uncertain, and we're talking about scenario analysis. So I think that's also an interesting aspect which we've been debating, and I see companies are concerned.
Thank you. Israel?
Thank you, Angelo. A couple of questions that, again, we received from colleagues where we consulted on this. One question that came up is that, according to them, the discussion usually on this issue, there are some states which would see it as problematic, that the regulation or any guidance would say that you should prefer the environmental judgment, the environmental criteria to the business profit-making criteria. So we're wondering if in your work with states or from the private sector, if that is indeed an issue, if there are such attempts, and what do you understand the state general international community or state reaction for this kind of regulation, which really posits this conflict, and what to do if there is a conflict between these two considerations, a business consideration or an environmental consideration in context of climate change. The other question that came up is that, according to what we understand from them, there is a general preference, at least by some states, that the regulatory frameworks on this would not be the general regulatory frameworks. So not regulatory frameworks about private or commercial international law or private or commercial law, but rather through the environmental regulation. So, and that is, of course, would impact what we do here. And then the question is whether there is an advantage or a disadvantage to regulation which is general, which is maybe something that UNCITRAL can do, but compare it to environmental regulations, which is probably something UNCITRAL would not want to dwell into. Thank you.
Vesselina would like to take that?
Thank you. Very quickly on the two. So it's a very valid point, the first one. So I'll address that in particular. Now, I think it was mentioned that the EU's approach is focused on double materiality, which is really the risks that climate change has on the company, so on the financials of the company, but also the impact, so what the business of the company, the impact is having on the environment and the society. And I will draw a parallel. The IFRS ISSB, the new standards that we spoke about, their aim is to provide this climate-related sustainability data to financial markets and to be useful to investors. So their materiality is very much defined in line with the financial materiality of IFRS. So some say that this is financial materiality, so comparison between the two. Now, and I've been involved in the working groups of both. So while this is the case, and I see now how the whole trend is moving, in the standards for the climate sustainability standard S2, when ISSB explains what are sustainability risks, they also go further to say that sustainability risks and impacts are also those that the company's production or company's business has on the nature. So what they call is we have to assess the dependencies. So they don't say necessarily impacts, they say the dependencies of the company on the nature and the natural environments. So the example that is provided is, so if a company pollutes water and down the stream, it relies on suppliers that use this water for their business models. This also has an indirect financial risk to these companies. So my answer to you is, I don't think these two are in conflict. What is critical is to see that the company's risks are not limited only to the entity itself, but really it extends beyond it to the value chain, to all the businesses that it depends on in order to produce and offer the product or the services that they're in the business of. I think this is in a very elegant way. We're focusing on the financials, but we're closing the loop, and we say the companies also need to assess their dependencies. So that's how we have approached that.
Thank you. Katharina, would you like to add something?
Well, just to underline that it's actually a risk. We're assessing the risks coming from climate change and sustainability to the profitability. That's what the standards are about. And Amazon, we are committed to investing in sustainability because it's a win all around. It's good for the planet, but it's good for the business and for our customers, and we're a customer-centered business and for our communities. So.
The observer from the International Bar Association, please.
Thank you, moderator. This is following on from your question earlier on, which deals with the dispute resolution aspects of climate change litigation. And there is some work that is being done on identifying the type of capacity for dispute resolution. So there are examples such as the New South Wales Land Environment Court, which is a leader in this particular area, where standard litigation cannot deal with all of the issues because the underlying tenet, I suppose, is the development of change of behaviour. So some of the areas of consensual dispute resolution, such as facilitation, mediation, identification of stakeholders, is something which is being modelled at the moment to deal with the 21st century disputes because they are value-laden. So I thought I would note that not all of these types of disputes will be able to be dealt with through the traditional models because they don't start with identification within the substantive law of a particular country. Even though regulation and so forth are developing, they don't necessarily change behaviour in the long term.
Thank you very much. That's already, we're anticipating a topic that certainly will come back to in this afternoon's panel on dispute resolution. But thank you very much for that information. Do we have any other questions from the floor? Yes, the European Law Institute.
Good morning, everyone, and thank you also from my side for the brilliant presentation. As the Green Claims and Greenwashing Initiative of the European Union was mentioned, I would like to ask your opinion on the circumstance that from the scope of application of that proposal, micro enterprises were excluded. And micro enterprises being enterprises employing up to 10 employees and having annual turnover up to 2 million euros. And this is, in my opinion, an exclusion which may create a loophole in the consistency of the legal framework. And I wonder whether for the purpose of clarity, because we already know that in several parts of private law we have a lot of information duties, and this we know that too much information is no information, whether it would make sense to create a kind of a green claim to information form, such a format to follow in order to comply with, and to also for the purpose of accountability and of at a later stage for showing to the court the compliance with duties and fairness at the level of green claims. In this sense, perhaps a useful tool could be a digital product passport along the lines which the European Union is proposing in the forthcoming regulation on eco-design, which also includes the provisional product passport. I would like to know your opinion about this aspect. Thank you again.
Veselina?
Thank you for this question. So indeed, as I mentioned, the greenwashing legislation is very welcome and very needed. It has to be, of course, consistent, but it also, I think we also need to be reflective of the burden such regulation would cause on small businesses. I think the thinking of also the Commission is to be a bit more kind of to make it business relevant. So going for very micro enterprises and imposing certain obligations with them has to be balanced against the costs involved. That being said, as you're already familiar with the Corporate Sustainability Reporting Directive that would apply across many businesses, as was more than 40,000 businesses by 2027 in the EU. This legislation is underpinned by the sustainability standards of the European Union, who are also quite sophisticated. But there is a separate working group that is simplifying those standards to make them easy to use by SMEs. So there is a separate process for SMEs on how they should incorporate sustainability and what would be the reporting requirements, not that burdensome as the large companies. But of course, the thinking in the Commission, as far as I'm aware from my work, is that large businesses will have to report on sustainability risks and impacts, and this data they need to gather from their financial institutions, their sub-borrowers, or in the supply chain. So every business, indirectly or directly, will be affected one way or another.
Well, Thank you very much. I'm sure you'd have many more questions to ask to panelists that were as brilliant as this, but we have exhausted the time allocated for this panel. I see the speakers of the next panel and the moderator are already in the room. So with that, I would close this panel and invite those to take our seats, but join me first in showing our appreciation to our speakers today.
Bonjour, et c'est un honneur et
Good afternoon. It's a true honor and a pleasure to be here with you and to moderate this sixth panel of our colloquium organized by UNCITRAL on climate change and law and international trade. Now, the subject matter of this sixth panel is as follows: greening the supply chain. Our panel will address contractual mechanisms for the implementation of greening of the supply chain and the related responsibilities to be established or to be defined. The idea here is to identify strategies available to operators in the private sector in order to promote sustainability within their supply chains, in particular by integrating accountability or compliance mechanisms in existing commercial practice. I have here with me three experts at my sides, and on behalf of the UNCITRAL Secretariat, I would like to very warmly thank each of them for joining us here in order to address us in person at this panel. To save a little time, I'll present each of these speakers separately before giving them the floor. And our first expert is Madame Yessim Atamer. Madame Atamer joins us from the University of Zurich, where she has a chair, professor of private law, trade law, and European comparative law. Madame Atamer is a renowned expert in the United Nations Convention on International Sales in Goods, the CISG in English. Since 2013, she has been a member of the Advisory Council of the CISG, which brings together a group of university experts who issue opinions on the Convention, its interpretation, and its implementation. In her statement, she will be commenting on the CISG and in particular will be highlighting a certain degree of tension that she has identified between buyers' expectations, those of suppliers, and potential claims regarding third parties addressed by protagonists in the supply chain. Madame Atamer, you have the floor.
Yes. Ladies and gentlemen, thank you very much for this kind invitation, and thank you very much to the UNCITRAL for this very timely conference, I must say. The topic is the CISG in the crossfire. In the previous session, we had several questions regarding liability, and I think this is exactly also the session where we are going to speak much more about this liability. Now, the idea of this conference, I understand, is to look into the UNCITRAL instruments, whether or not they need any change, especially to combat climate change. What I'm going to look at today is the CISG, that is the Convention on the International Sale of Goods, whether or not it has any impact in this regard. 95 contracting states we have nowadays to the CISG. That means, is there any liability due to a sales contract? This is going to be the question. What are the challenges due to the new developments? Let's call them new. We have two problematic issues. One is downstream. That means on one side, we have buyer expectations regarding sustainability. That means the goods are perfectly fine. What you are delivering, the computer is working, no problem normally, which we expect under the sales contract. However, the production process of the supplier, manufacturer is tainted. That means we have a sustainability issue. Do we have remedies because of this under a sales contract? This is a first question. And second, the question is, if we go upstream, that means the liability of the manufacturer for production processes of his business partners. Again, the goods are perfectly fulfilling their function, but the production process is problematic. Third parties have a liability claim against the manufacturer. Is the CISG answering to this in the redress? Now, I'm going to make use of this scheme all the time. You see it is a bit complicated, but I hope you can see where all we are going to apply the CISG. That means whenever we have an international sales contract, and obviously I'm assuming that the parties have not excluded the CISG. That means with 95 contracting states, we can assume also that often the CISG is also applicable. That means whenever we have an international sales contract, the CISG is going to be confronted with two problems. On one side, we have the downstream, as I said, the end purchaser under the CISG claiming that the goods were non-conforming because of sustainability issues. On the other hand, we will have some environmental tort claims, which again then are going to cause a redress in the sales chain. Let's go first downstream. That means what exactly is happening here in this part? We have the manufacturer. Either it is an end purchaser directly a CISG claim, or we go further down the line, then we have the redress claims. Now, we have sales contracts where we have, for example, goods which are produced with wood, which is sustainably also produced. Or we have an oil producer which is achieving net zero emissions. Or we have burgers at the end of the day, but they are again produced out of meat where we have not at all deforested. These are the claims which we have in our sales contract. Now, if that is not correct, what then? What is the CISG reaction exactly to this? That means, first of all, we have to have a look at the non-conformity rule, that is Article 35 of the CISG. If in these cases we had the furniture manufacturer and the Forest Stewardship Council, the FSC Council seal is there, we would assume this is also a contractual matter. But if they are not produced, likely, what then? If the delivered oil was produced causing an environmental disaster, if the burgers were made of meat of cattle raised in deforested land, is that a CISG non-conformity issue, even though, as I said, the burgers are perfectly fine? So that means, first of all, the question would be, is there a contractual regulation regarding that? Here you see one of the largest chemical producers in the world. In their supplier code of conduct, they see you, as the supplier of oil, comply with all applicable environmental, occupational health and safety regulations. You promote the safe and environmental sound development. As you see, this is not a duty of best effort. This is a duty to achieve a specific result. So that means we would say here we have a contractual provision and it would cause liability. Again, the problematic with the FSC seal. You didn't say anything in addition as the supplier, but you have an FSC seal. What does that mean? That you are also that you are also producing according to these seal requirements. If you are violating this and the furniture is made of protected tropical wood, for example, then again the remedies of the CISG are going to be applicable. That means Article 35 regarding the non-conformity under the CISG is wide enough to cover these type of claims also. If we do not have any code of conduct agreed upon, if we have no seal at all, would still sustainable production be part of the sales contract? It might be, because we have Article 9 of the CISG, of the UN Convention on International Sales, which is providing for gap filling in the contract. That means usages and practices established among the partners can become part of this contract according to Article 9.1. What does it mean? Previous inclusion of supplier-manufacturer code of conduct, for example. Both parties are member to UN Global Compact, or we just heard from Amazon, they have this climate pledge. Or best business practices published by commercial chambers, they made also use of. That means just referring to this means already that these requirements can become part of the contract, and that means that they are binding on the seller-supplier. We might also have an international trade usage. If you are, for example, selling diamonds, the Kimberley process certification scheme is meanwhile that widely known and applied that we would say, without the parties even mentioning it, that would again become part of this sales contract. But again, we might also have cases where we cannot have at all any information regarding this. Nothing was said about sustainability. Still, Article 35.2 of the CSG, litera A says, the goods have to be fit for the purposes for which goods of the same description would ordinarily be used, or for any particular purpose. Now, the question arises, who exactly is defining it? Are these the standards of the buying market? Are these the standards of the resale market? Are these the standards of the supplier? This is going to be the question. For example, on 31st of May 2023, the EU adopted a new regulation on deforestation and forest degradation, so to hinder it. That means some commodities like cattle, cocoa, coffee, oil palm, rubber, soya, and wood are not going to be, or goods made out of these goods, are not to be introduced into the EU anymore if they were based on deforestation. That means, remember, the burger. Does the seller, the supplier, have to know about this also? I'm assuming, obviously, that these standards must be there at the moment of contract conclusion. After contract conclusion, nothing can change anymore. But at the moment of contract conclusion, I didn't say anything at all. But the seller knows that the goods are going to be transported and sold in the EU. Does that mean that we here again can hold the seller liable if there is no compliance with these type of goods? Now, Article 35.2 of the CSG doesn't explicitly say something regarding that. The CSG Advisory Council, which you also mentioned, where I'm a part of also, has some suggestions, but these suggestions are all based on national case law. That means all around these 95 countries and also other countries which are not party to the CSG, the courts also have to decide on applying the CSG. What do they mostly apply as criteria? They have a look at the sales contract, whether the buyer has drawn the seller's attention to the standard. That means the buyer, if she should be more knowledgeable, must also refer to these standards. Whether the seller has expressed a public commitment to the standard, and I think this is going to be more and more important in the future. How are we going to qualify a CS report? That means a corporate sustainability report of a company, which is normally only for the shareholders. Again, in the last session we heard, we have now meanwhile also a stakeholder view. That means we have this double materiality. That means these CS reports are not only published for the shareholders, but also for the knowledge of the stakeholders. That means if I publish something like this, if I'm a seller and selling oil, for example, and in my CS this is stated, then I have to also abide by it. And that means if not, I might have a liability under the sales contract. That means the party's expertise in relation to these goods, or the price. You can imagine the higher the price, the more are also the expectations of the buyer sides. These are all going to be of importance. To be on the safe side, if you are in an international sales chain, what one should do is really to express provisions regarding sustainable production processes in your contract. That means, what are you expecting? Like we have seen from the BISF, that we really have that in the contract. And second, that we have expressed provisions regarding penalty, or according to which jurisdiction you are, liquidated damages clauses, because it's not easy to prove that you have encountered a loss also because of that. But that's too much of a detail. I can now not speak about it. That means here, the problems regarding downstream. What is going to happen upstream? Upstream is problematic, a bit more sophisticated. Why so? Because we have third parties. Third parties claiming against the manufacturer. Why so? Because the manufacturer has breached some obligations. Now, you see in this scheme, it was not the manufacturer himself, herself producing, but the raw material producer who caused an environmental damage. Property claims are arising. You might sue the raw material producer, obviously, but you can also sue the manufacturer. Why so? Why so? Because we have now more and more laws. This is the proposal of the European Union, the so-called CS3D, Corporate Sustainable Due Diligence Directive, which probably is going to come into force in 2024, which obliges companies, not only big companies, but also more and more SMEs, micro companies are only excluded, to oblige to conduct a human rights and environmental due diligence. That we have heard about in the morning. But what else, what additionally has to be done? If you are not complying with these obligations and you intentionally or negligently fail to comply to do this, then you can be liable for damages based on a tort claim. That means, think of this scheme again. We have the manufacturer who is now directly liable for tort claims. But what are you then going to do as this producer? You are then going to ask in the upstream chain this time, the deliverer of the part goods or the raw materials to compensate your losses. And this is again a CISG claim. It is a sales damages claim according to Article 74. That means I am going to pay for the third-party claims, but the problem is I can again ask also the raw material producer that she, at the end of the day, carries my losses. Now, what we are going to have here as a huge problem is, can we apply Article 80 of the CSG? What is Article 80 about? It is about contributory negligence. That means, can the raw material producer say, but you have never controlled me according to the rules you should have done. No due diligence obligations was fulfilled. You were asking for low prices all the time, and that was what I did to give you these low prices. Can we say that in a pure sales context, suddenly we have this whole discussion, who really has the obligation to fulfill these due diligence mechanisms? Now, to conclude, I would say that the CISG is up to these new challenges. We do not, in fact, need a change of the CISG. However, I think the UNCITRAL would be well advised if we would form a model clause for the contracts. That means a model clause including exactly these issues like mutual obligations of the parties. Who is in charge for what? The remedial schemes, that means what I just talked about. To ask for damages is one issue, but on the other side, we also have other sales law remedies. Which of those can be applied? The buyer remedies, dispute settlement issues, which was going to be discussed later on. And we see, or I have found at least as an example, the American Bar Association, for example, has now introduced a model contract clause to protect workers in international supply chains. This is just one aspect of the issues, but I think we need more and more these type of model clauses. Thank you very much for your attention.
Merci, Madame Ansamer.
Thank you to Madame Adama.
J'aimerais maintenant souhaiter la bienvenue et donner la parole à Monsieur Christian Richter-Schoeller. Monsieur Richter-Schoeller est associé principal du cabinet juridique viennois Dorda. Au sein du cabinet Dorda, Monsieur Richter-Schoeller intervient notamment sur les secteurs banque et finance, l'assurance, industrie digitale et les marchés de capitaux. Il est en outre co-responsable à Dorda de la branche durabilité. Monsieur Richter-Schoeller est aussi chargé de cours à l'Anwalts Academy,
also
the head of courses at
Anwalts Academy, where he often speaks to universities in Vienna and abroad. Mr. Richter-Schoeller, please.
Thank you. Thank you for the introduction, and thank you so much for the invitation. I just said to you, I think it's a great idea, it's a phenomenal idea that the UN is doing this panel, is doing this colloquium on climate change. It's, as you said, it's just the right time, I think, and it's simply a good idea to collect diverse experience from all over the world on this topic, because I think this will be, and we're talking now about supply chain legislation, I think this will be one of the key changes in the legal framework around ESG that we will be seeing in the next couple of years. My name is Christian Richter-Schöller. I'm an attorney co-heading the ESG group at the Austrian law firm Dorder and also heading an international network of lawyers specializing on ESG. My speech is based on my practical experience when working with clients on implementing mandatory supply chain rules. I will emphasize on the challenges my team and me have come across, explain how we address them, and in the end suggest how the UN and specifically UNCITRAL could be of help in mitigating those challenges in the future. So the first part of my speech will be around the mandatory supply chain laws. My advisory work on supply chains is usually triggered by one of two things: either companies directly affected by mandatory supply chain laws or suppliers of companies directly affected by mandatory supply chain laws, and they are passing on their obligations to my clients or to suppliers and those suppliers to my clients. So essentially, who is within the scope of supply chain laws doesn't really matter that much. In the end, it will affect anybody, and in the end, it will affect especially SME, who will not be directly within the scope of the supply chain rules, but who will almost certainly have, at least somewhere along the supply chain, a contractual partner that is in scope, and that's why, from a contractual perspective, they will be asked sooner or later to also implement those obligations. Now, when speaking of mandatory supply chain laws, from an EU perspective, 3 laws come into mind. It's the French Loi de Vigilance, the German Supply Chain Due Diligence Act that entered into force beginning of this year, and the draft EU Corporate Sustainability Due Diligence Directive, the CSDDD, as you already mentioned. I think, and that's why I'm focusing on the CSDDD especially, but all of them have common elements that for me represent supply chain rules of modern variety that, in my opinion, will be a model for future supply chain rules around the world. Because there's 2 things that set them apart from previous supply chain rules. First, they apply to all industries, industry agnostic. Whether you're a textile industry or whether you're a credit institution, it doesn't matter, you have to comply. Secondly, they apply to the whole ESG spectrum. It's not only climate, it's not only social, it's the whole ESG spectrum. Now, there are 2 common elements that all of those supply chain rules of modern variety, in my opinion, have shown. First, they define environmental and social rights that need to be protected from a mandatory perspective. So they define the protected rights. And the second common element, they contain obligations how, when, why adverse impacts on those protected rights have to be monitored, and obligations on what you have to do if you identify adverse impacts in the course of your monitoring. So it's a definition of ESG rights and its obligations, what you're going to do. So recurring obligations to monitor and obligations what you have to do when you find out there's actually negative impacts on those ESG rights. Based on those common elements, on those 2 common elements, supplier contracts will have to be renegotiated. That's, from my perspective, the most time-consuming process when we're talking about implementing mandatory supply chain rules. There will have to be certain sets of new rights that will have to be included in supplier contracts. First, that's the ESG foundation. That's, simply speaking, implementing in the supplier contracts the protected rights relating to ESG factors. For example, the CSDDD specifically emphasizes climate change, so you set the goal net zero, you implement it by an individual decarbonization path together with your supplier, and you monitor that by defining certain GHG KPI that you get on a regular basis, and if something goes wrong, based on those KPI, you have to do something about it. So that's the first set of rights. You implement the actual ESG rights that the mandatory law asks you to implement. And now, and I think that's an overlooked part, there are certain sets of new rights that don't directly relate to the protected ESG rights, but that are ancillary rights that you also need to include. You need information rights, because without information rights, you can never track whether the ESG foundation that you agreed on is actually observed by your supplier. You need steering rights to mitigate any adverse impacts that have been identified. That's something I think that was very well emphasized in the speech by Katharina Bryan before me, because she said CSRD, it's not about compliance, it's about transformation. I think that's exactly the point, and that's even more true for the CSDDD, because the CSDDD, unlike the CSRD, not only asks you to publish information, but you also have to do something with the information. You have to steer, you have to mitigate adverse impacts. Then you will need compensation rights for monetary damages for a breach of the ESG foundation in the supply chain. The legal basis for the monetary damages could be administrative fines because you're directly in scope of the law, or it could be tort claims that you are facing from your own direct suppliers. So you need compensation rights. And the CSDDD also says you need termination rights, because in severe cases where there are severe adverse impacts to ESG rights and you can't mitigate those ESG adverse impacts, in those cases the CSDDD says you will have to extraordinarily terminate your supplier contract. You will have to delist your supplier in case there is a severe negative ESG impact, and in case you kind of exhausted all your remedies to mitigate this negative impact. You will need obligations to pass the obligations along in the value chain. Now, the German law and the EU directive differ on this part, because the German law says you only need to monitor your direct contractual partner, and the EU directive says you need to monitor the whole upstream and downstream value chain. As you said, I think the discussion is pretty much over. The supply chain rules in the future will relate to the whole value chain. This tier one concept that the German Act introduces, I think it will not be the future when we're talking about supply chain laws. So you will definitely need obligations, asking your supplier to pass that obligations on to its own suppliers, and so on and so forth, so that the whole value chain is actually aligned with the law. And because we're living in a world of uncertainty, especially regarding supply chains, you will need to have rights to demand amendments, or at least good faith renegotiation in case supply chain rules changes, in case there are model clauses that become mandatory, etc. Now, not all of those rights will be required to be explicitly in every supplier contract. If your supplier is subject to mandatory ESG reporting, you will probably not need additional contractual information rights that are, from a material perspective, already covered by the mandatory ESG report. But from an essence point of view, those are the sets of rights that will have to be reflected in your supplier relationship, either be it from a mandatory perspective or from a contractual perspective. You will have to have those rights vis-à-vis your supplier. And those sets of rights will generally have to be mutual, so supply chain works both upstream and downstream, as you said, and you have to consider whether there lie any ESG risks with your supplier, as well as whether you distributing the product bear any ESG risks yourself. So it's an upstream and a downstream exercise you have to do, and this probably helps in contract renegotiations, because both parties will have an interest to include those provisions to a certain degree, but from a principal point of view, both parties should have an interest in doing so. Now, we talked about can you put on the next slide, please? I think the remote isn't working. Thanks. Now we talked about implementing the mandatory rights from a contractual perspective. Now the question is, what are you going to do with those sets of rights? It's faced with major hurdles at the moment, because it's a completely fragmented world out there, which leads to a Wild West approach. Companies ask their contractual partners to comply with its own supplier code of conduct and pass that code of conduct on to its own suppliers. But those contractual partners face not only one such request, but multiples. We've been working with companies having 30,000 suppliers on tier 1 level and 12 million suppliers on tier 3 level. This lack of harmonization is actively preventing supply chain rules from being effectively implemented. And this hurts SME the most, as you can imagine, because those are the ones that practically bear the risk of the vagueness of the law and that are practically bearing the risks of all of those supplier code of conducts that are passing down the supply chain. Now, before this background, UN and UNCITRAL could, from my perspective, play a major role in the much-needed harmonization of the rules, and this is touching on something that you mentioned on the model clauses part. You already pointed it out previously. First, regarding the ESG Foundation, it's important to note that a lot of the supply chain laws currently are based on existing UN documents, for example, the UN Framework Convention on Climate Change or the UN Declaration on Human Rights. They already serve as a basis for much of the ESG Foundation. The challenge is that, of course, those documents usually address not companies but states, and looking through a contractual lens also leave a lot of room for interpretation. Now, UN and UNCITRAL could basically serve the harmonization regarding the ESG Foundation in two ways. They could, from my perspective, specifically name UN documents eligible for referring to when implementing the ESG Foundation. So certain UN documents could be listed that can be an external reference part for ESG Foundation. And what could also be done is that taking certain material documents and transposing selected relevant part of those documents into more actionable, descriptive pieces to be used for model rights, for model clauses. There's the prescriptive approach. You name documents that can be referred to in other contracts. And there's the descriptive approach. Out of those UN documents, UN UNCITRAL could kind of model rights, standardized rights that can be used more or less word by word, at least to negotiate off as a common neutral ground. That's regarding the ESG Foundation. Regarding the ancillary rights, the EU directive expressly refers to consultation with international bodies when it comes to developing model clauses and issuing guidelines. Even if there's no express reference to such consultation, the development of model clauses by UN and UNCITRAL could support the harmonization because, as I said, at the moment it's a wild west out there. There's no market harmonization whatsoever. To give you a practical idea of what this means, you will have to have information rights, as I said. So from a formal perspective, the question arises, who shall be obliged to provide whom with what, which form at which time. Those details matter a lot because I've seen practically every approach you can imagine, starting with ad hoc, the right to ad hoc audits on premise of sub-suppliers to, and that's the other end of the spectrum, to basically the party being allowed to assume without further investigation that everything is okay unless it accidentally happens to acquire positive knowledge of the contrary. So it's a widely different approach that is currently practiced, no standard, no market practice whatsoever. And model clauses for ancillary rights issued by the UN and UNCITRAL could serve as a perfect starting point for such market standard and at least, as I said, allow for a negotiation of a common neutral ground for both parties or for multiple parties. Based on my experience, it's actually, and interestingly enough, of less importance what mandatory framework lies underneath. For example, both the German Act and the EU directive do not expressly say which kind of information rights you need. It only has to be effective. You have to have effective right for information. And this is actually an advantage when drafting model clauses because the content of such clauses, in my experience, is largely driven by the general commercial law aspects. In a nutshell, this usually means which information rights would I like to see if it were not ESG and non-financial information? but financial information I would have to keep track of. And this also speaks for the UNCITRAL being able to help in drafting, as the essentially ESG agnostic nature of the CISG could be preserved. Thank you for giving me the opportunity to present this to you, and if you have any questions, I'm more than happy to answer them now or later. Thanks.
Merci, Monsieur Richter-Schoeller.
Thank you very much.
Now,
finally, I would like to give the floor to our third speaker, Ms. Ipshita Chaturvedi of Singapore. Ms. Chaturvedi is a specialist in commercial law and in environmental law, a partner from the legal cabinet Dentons Roddick in Singapore, representing Dentons Roddick, and within the Dentons Roddick cabinet, she co-chairs the section on environmental practice and natural resources, comprising carbon transactions, climate funding, the concept of responsible enterprises with regard to human rights and biodiversity, supply chain management, as well as environmental and social aspects in merger-acquisition transactions. In her presentation, Madam Chaturvedi will address contractual clauses known as ESG, that is, clauses relating to the management of environmental and social risks and governance, as well as the so-called green clauses in industrial and in manufacturing contracts. She will in particular focus on key issues related to the greening of the supply chain from the contractual angle by sharing with us her experience as a commercial lawyer, providing advice.
Merci beaucoup.
You have the floor.
Je vais parler en anglais.
I'll be speaking English.
Good morning, everyone. It's an absolute honor to be presenting to you about supply chains, so big thank you, UNCITRAL. Supply chains know no borders. They are fluid, they are dynamic. They seek only to please and to get the work done in the most cost and resource efficient manner. And they were a great sense of solace to all of us during the pandemic. Sometimes I feel we should all be like supply chains. Now, I'm a commercial lawyer, and my firm advises MNCs on, like Christian, to very practically advise companies on how to identify and mitigate supply chain risk. When we started examining this, the first question was, what exactly is a supply chain? Like many others, I did think that supply chains are linear, that you have a clear idea on the end user, the retailer, and then the transporter, perhaps another level of suppliers, and then the manufacturer. Nothing could be farther from truth. In reality, supply chains are a multifaceted demon, a complex spidery web, full of suppliers, sub-suppliers, vendors, and users, including technologies. It's the entire process of procuring and then transforming raw materials into finished goods for consumers. And it covers the product, the process, and the production method, as well as R&D, product development, and information systems. What is supply chain sustainability, therefore? Supply chain sustainability is integrating environmental and socially responsible practices into the way we procure goods, which includes manufacturing, packaging, and retail, put simplistically. In a simple enough supply chain, there will often be at least 3 to 4 jurisdictions involved. Now, once we knew that supply chains are very, very difficult to track and understand, the second question was, what is the obvious risk when we are talking about supply chains? And there are 2. One is the environmental impact, and that, unfortunately, is narrowed down only to GHG emissions, the way law is articulated today. And the second is forced labor or human rights. Since we are talking about greening the supply chain and this panel is discussing that, I will limit myself for the next 10 minutes only to the aspects of decarbonizing supply chains and what really is the melange between commercial contracts and public international environmental law. Where is that interface? The reason why companies are looking to green their supply chains, because they weren't 5 years ago, I promise you, are 3. Fear, opportunity, and compliance. Christian did a very good job of the compliance and the new laws coming up. Fear is from sanctions, fear is from risk of litigation, both from stakeholders and shareholders, as well as fear of greenwashing. Opportunity is when companies understand that increasingly consumers are willing to pay a higher price for goods that are made sustainably, and that's where they have a competitive advantage. Those goods, however, are often very expensive. And the third is, as Christian spoke about it, compliance. Since he covered the French Loi de Vigilance and the EU Corporate Diligence Directive and the German law, perhaps I could give an example of the EU Carbon Border Adjustment Mechanism, which I will call the CBAM, and how this impacts supply chains around the globe. The transitional phase has kicked off now in January this year of the CBAM, and it's supposed to cover 5 industrial sectors, so it is not sector agnostic, which is iron and steel, cement, fertilizers, aluminium, and electricity generation. The transition period ends in December 2025, and after that, the European Commission will evaluate if the ambit of the CBAM should be expanded to include indirect emissions and to products further down the supply chain. And then importers will need to obtain the relevant authorization from the CBAM authority. This would include purchasing carbon certificates, which will be priced in correspondence to carbon prices that would have been paid to produce the same goods in the EU. Therefore, in a nutshell, in order to comply with the new law, affected companies, particularly in the manufacturing-intensive regions of Asia, of Latin America, and of Africa, will have to, at the very least, calculate their GHG emissions, and then conduct a cost-benefit analysis to see whether it makes more commercial sense to offset emissions in their jurisdictions or to pay the border tax adjustment. A similar thing on disclosures is also proposed by the US SEC that has published guidance calling for greater disclosures by listed companies on the risks and costs of climate change on their businesses. And we see similar laws burgeoning in every part of the world. It is surmised that about 80 to 90% of a company's greenhouse gas emissions happen in the supply chain sector. So they will not happen in their front offices, they will not happen in their headquarters or in the liaison offices. They will actually happen down the supply chain where the manufacturing is happening, where the transport is happening, where the goods are being warehoused. So therefore, any company that is impacted by compliance or has any kind of voluntary net zero target will necessarily, and I say necessarily, have to impose disclosure requirements at the very least, and maximum decarbonization efforts to suppliers down the supply chain in jurisdictions that they do not have a control over. And this is where public international law comes in. Now, there are 2 options for companies, the way they decarbonize. One is that they buck up and they decide to do it themselves. So they will take stock, the very least, they will ask for data from the suppliers, and then they will offset their scope 3 emissions, which is the supply chain. How will they do that? They will either install renewable energy in their manufacturing sites, or they will look at purchasing renewable energy credits, or they will enter into off-site power purchase agreements. And last but not the least, love and hate, they will look at carbon credits for any kind of surplus emissions that's remaining. When the company pays for all of this themselves and decarbonizes, no feather of international law is ruffled, so far as I see it. However, in practice, there are companies who are passing on the responsibility of decarbonization through back-to-back arrangements to counterparties down the supply chain. And there is no system currently that prevents them from doing so. These companies are relying on contract clauses, model or otherwise, requiring their suppliers to decarbonize. These clauses are often cookie-cutter and drafted very loosely without understanding or enumerating what liability mechanisms should be in case the supplier is not able to meet those requirements. This is deeply problematic because in jurisdictions where those laws do not exist, suppliers are completely okay, and we see this every day, giving false declarations, providing any sort of data, incomplete disclosures, simply because there is neither opportunity, nor fear, nor the need for compliance. On top of that, there's also a possibility that just for business continuity, some of the suppliers could reach out for the lowest ranking, cheapest carbon credits and just buy them off the market, thereby also threatening the integrity of the carbon markets themselves. I guess the main question to ask in this entire scenario is, whose job is it to pay for decarbonizing a supply chain? And is it the responsibility of all, or is it the MNC that is in a developed part of the world? If we go back to the Kyoto Protocol days, jurisprudentially, and this is just a question, can an X1 country end buyer pass on the cost of climate reparation to a manufacturer in an LDC? And do current modes of supply chain decarbonization through commercial contracts dilute or perhaps even obliterate common but differentiated responsibility under public international law? Should there be an interference by bodies such as the UN and UNCITRAL to protect SMEs in developing countries from such a risk, from such a cost being passed down to them? What a forum like this can do, because I was thinking about it, there's no point talking the dollars and cents of a contract here. But what a forum like this can do is actively help in prepare guidelines to provide clarity on 3 key points. The first is, what constitutes effective decarbonization of supply chains with the point of view of robustness of the decarbonization techniques, which includes carbon credits? And do we want to focus just on GHG emissions, or do we want to take a broader view on sustainability, which will include planet as well as people? And in that case, we will have to look at wider SDGs rather than a narrow view of just GHG emissions. The second is prescription on who is to bear the cost of decarbonization, and preparedness to pay more for products that are sustainably made. Products that are made sustainably with good labor standards and decarbonized products will cost more. Are we willing to pay more? And third, addressing the issue of extraterritoriality and harmonization of laws. How deeply and can laws of one jurisdiction influence another's through supply chains? Because suppliers now are increasingly required to carry out periodic risk analysis for their deliveries, to implement appropriate preventive and remedial measures for emissions, all of this costs money, and this involves the insertion of laws from one jurisdiction into the company, into the supplier, and therefore indirectly into another jurisdiction, where commensurate regulations do not exist. So whose standards should apply? I'm aware that these are very difficult questions, but they are necessary ones, and honestly, we wouldn't be here otherwise. Thank you so much for your time.
Thank you. I think we're well in time for some questions, if you have any. I see a question from the Ivory Coast. UNITRAL. Monsieur.
Je vous remercie.
Thank you very much.
Je vous remercie pour vos brillantes interventions.
Thank you all very much for these excellent presentations. My question really is for Madame Yassim.
Pensez-vous?
Madame Yassim. Madame Yassim. Yes. Can you hear the interpretation?
No, I can hear. So could you translate?
Can you hear the interpretation? English interpretation?
Could you repeat the translation, please? No. No?
C'est bon? D'accord. Je vous remercie.
Thank you very much.
Donc,
As I was saying, this is a question for Madam Yassim. Madam, do you feel that the convention is reasonable, or do you feel that it impedes or hampers development in one way or another? Let me explain. I come from what is mostly an agricultural country, global leader in cocoa production, third in coffee production, other products also. Banana, for instance, which are mostly exported to the EU and other destinations. Now, these products, how are they governed? To a large extent, these products are the result of deforestation. Now, we've been talking about responsibility for deforestation, and this responsibility is being claimed as the responsibility of the commodity producers. But what about the end users, the consumers of the product at the end of the process? Thank you.
Thank you very much for the question, and sorry for the delay. I think this question is not on my side to answer, because this is an EU regulation which I gave as an example. And this EU regulation is separate from the United Nations Convention on International Sales Law. That means, in that regard, you are absolutely correct. It's, I think, also what Ipshita said, that we must always think about who is going to carry the costs of this issue. But if you look at the sales chain and the CISG, it is now going to be an issue. That means if these goods, for example, as you said, cocoa or banana, is produced via deforestation, the sales into a European country might be a violation of the sales contract. That means the liability of the producer could be viable under the CISG. That means either contractually this issue must be by the parties addressed, who is going to carry the liability, or otherwise one, as the producer, has to observe these production requirements, or EU is not going to be a place where you would be able to import or export to. But this is, as I said, a regulation of the European Union, and the CISG is just now in the position to adapt all these new requirements, and it's going to be important for the sales contract. One has to say that.
Merci, Madame Atamer.
Thank you very much, Madame Atamer. I would now like to give the floor to UNIDROIT.
Good morning. First of all, I'd like to congratulate all panelists for excellent presentations. Unsurprisingly, I'd like to complement what's been said about the CISG and generally to talk about UNIDROIT's own restatement of contract law, which are the UNIDROIT principles on international commercial contracts, precisely because of the way they've been drafted, their flexibility, and borrowing from the words of Professor Hans-Peter Berger, their relationality. They are particularly well suited, we believe, to serve as a vehicle for the implementation of the adequate clauses in supply chain contracts, both nationally and international. They are based in part on, in a very good part, as a tenet on party autonomy, and they can be incorporated by reference to the contracts, so that, for example, contractual terms that mandate compliance with environmental requirements, but not only, also duties concerning labor law and other elements could be added to the supply chain, regulating the contracts between the parties. And in that sense, I like to then say that this is an instrument which is not only adequate for environmental purposes, but goes beyond and enters directly into the realm of what would be corporate sustainability or corporate due diligence sustainability. Corporate sustainability due diligence, sorry. And we would do this, or this is done through the incorporation of express provisions on standardized terms, which really links with what Professor Atamer just said. Moreover, the UNIDROIT principles also concern all types of commercial contracts. So in that sense, it's particularly well suited for the entire supply chain because there are different types of contracts envisaged therein. There are a number of additional reasons and rules in the UPIC, principle of cooperation, the principle of third-party beneficiary, which not only allows for a third party to benefit from the contract, but also provides this third party with a remedy in case of no compliance, let alone a very good system, an efficient system in case of risk occurrence, which is shared with the CISG in many ways. They're particularly good and flexible in terms of problems that can arise in the supply chain, which is very volatile, obviously, because it concerns several contracts, often in several countries. So just wanted to raise also that this would be a very useful instrument. As a consequence of these, perhaps it was that some time ago, over a year ago, the EBRD, the IDLO, and later the European Law Institute on the technological side presented a proposal for future work, which is now in our work program, on corporate sustainability, the due diligence sustainability in the supply chain or in the value chain more particularly, which is a project that's there. So I just wanted to share these reflections with you, and thank you.
Add a word on this. I think it is very common also, meanwhile, that in contracts which are subject to the CISG, that the parties are also choosing the principles of international commercial contracts of the UNCITRAL as a supplementary. That means for anything which is not included in the CISG to then refer to the PICC, and I think that is very, very wisely, because these two instruments are both combining common law as well as civil law, I think, in a perfect way. So I would always favor not to go for a national law, but always to go for the PICC and the CISG. Absolutely.
Je crois que nous avons une question du délégué
I think there's another question from the delegate of Panama.
Muchas gracias, señor presidente.
Thank you very much, Chair.
Más que una pregunta, quizás es
More
una
than a question,
preocupación,
perhaps rather this is a concern
porque
or a
en
misgiving.
la cadena de suministro, una parte
In the
importante
supply chain, a
es el
significant
consumidor
component is the individual consumer.
Creo que se está hablando
And it seems to me
del problema
that we've been
macro
discussing
que va
the macro
en
issues at
intermediarios,
stake
pero
and
también
the other
hay
intermediaries
quizás no el
concerned,
tema de
but perhaps
UNCITRAL, pero
this may
la
not be necessarily an
modificación de la
UNCITRAL matter,
conducta
but
debe ser también el
modification of
consumidor.
conduct or behavior
Más
of the
allá
end user, the final
de que
consumer.
El valor o los precios de los
Above and
productos
beyond the value or the
que son
prices
producidos en
of these
cumplimiento
products which
de los
comply
estándares, de protección medioambiental
with
son
environmental
mucho más
protection
caros.
standards. These are, of course, costlier products.
Entonces, si no se modifica
Accordingly, if there is no change to the behavior of the individual end user, well then, the process is incomplete.
entonces también hay que tratar de
So once again,
identificar esto
this is
en
something
todos
that
los
would
niveles
have to be identified at all
para
levels,
que las políticas macros
so that the macro policies
tengan ese impacto real
really can have that
puedan influir
tangible effect,
tener un impacto positivo
a positive
en el medio
impact
ambiente, que es lo que
on the
todos
environment, which is, after all, what we're all striving to achieve.
quizás la pregunta aquí sería
So maybe the question then is this:
cómo integrar no
how is
solamente
it possible
el derecho de los
to integrate not
consumidores,
only
sino la
consumers' rights, but
responsabilidad social de
also
todos
the
los
social
consumidores
responsibility
en
of
esa cadena de
all
producción para lograr
involved in this
las
production
metas
chain in order to
de reducir
meet those
los
goals
impactos del
of
cambio
reducing
climático.
climate
Muchas
change
gracias, señor
impact.
presidente.
Thank you.
For the answer, perhaps I will first give the floor to Ipshita and later to Ms. Atame. Question.
I do think it's difficult to answer this question because there's a little bit of philosophy and economics being the sovereign of the way we run the world. Consumers don't often make informed choices. Every day someone's telling you brown is the new black. this is cool or this is in. And we have to question who owns those messaging points and why would someone ask people to do the right thing if it doesn't serve them. And I think that's the wider question. So I think this is a question that probably should be answered by philosophers rather than lawyers.
Maybe a small addition to that. I totally agree. This is a very, very important point, absolutely. But I think at least in the European Union, which I could reflect the most, this side is also looked at. For a long period, since the 1980s, mid-80s, till really beginning of 2000, it was always consumer protection. So the consumer was in the foreground, more rights, but also in the background, the idea of more consume, and growth. So that means now the aim is that we grow still, but lesser, grow still, but greener, and the consumer protection issue. That's why I also was interested to hear about the OECD. In the new guidelines, it is still said consumer protection. I think this is now getting a bit more in the background. It is not that important anymore because the consumer has to learn also to not to consume that much. And also that we produce goods more durable. That means that they last also longer, that we are not changing it every year, our cell phones, but can use them for years and years. So the idea, the mindset is changing. And I think, again, this can be done by laws to a certain degree, but it's more education probably, which all have to change the mindset.
Thank you very much, Madam Atamer. I'd also like to give the floor to my colleague on the same question.
Thanks, and I agree with everything that has been said before. Just to add, why is and I'm again talking from an EU perspective here because that's what I'm familiar with. Why is the EU actually addressing companies and especially large companies in all those ESG laws that we are seeing, especially, for example, in the CSDDD? Because that's the mechanics behind the ESG EU regulation. It has an inherent top-down approach that we have been seeing in the world of sustainable finance, where first the banks and the insurance undertakings have been regulated, and then there was the hope that this is going to have like this behavioral trickle-down effect where finances and where capital will flow where it's more green. So this top-down approach is also applied when we're talking about supply chain laws. This is why the law specifically addresses large undertakings, but I agree, the retail consumer is actually the important piece here that is missing, absolutely. And I would even go one step further. All this regulation that we are talking about today, what is it essentially going to bring about? It's going to make products, services more expensive. Because it's putting, and that's not saying it's not a good regulation, that's not saying it's not a necessary and overdue regulation. It's just saying it's going to put a lot of strain on a lot of companies, especially SMEs, and this is going to lead to higher prices in products and services. And from a social perspective, from an inclusion perspective, from a social perspective, this is going to probably exclude a lot of people who cannot afford it from a lot of goods that are now suddenly too expensive for them. So yes, this I think is an important piece of the legislation that is overlooked when you're thinking about what is going to be the effect of the laws that we're talking about now. Because on paper it all sounds well and good, but in practicality, this is going to be one effect you can be sure of.
Merci.
Thank you very much. Thank you very much for all of the questions. And I believe that can bring us to a timely close of this panel session. But